This program is funded by the European Union.
Welcome back to the continuation of our previous session where we were discussing about labor issues in the Gambia. Mr. Barrow has taken us through a lot of useful information that I believe for some of us, or at least for me, has been the first time we have come across such information, which I believe the audience, the population, job seekers need to ensure that facilitate employability. He mentioned in the earlier session that at the Labor Department there is a session where, or an area where employees seeking job can register with them and deposit their documents and of course their qualifications and all other necessary documents, and also where employers such as corporations can communicate to them about availability of vacancies and the qualifications required to meet to fill those vacancies, and then the Labor Department will do the matching. He also mentioned that the mitigation part in terms of dispute resolutions between employer and employee, and also stated clearly that the Labor Department does not have judicial powers, that it also only seeks to reconcile dispute work issues at the workplace between employers and employees, and if in the case either of them is unsatisfied, they can further take this to the industrial tribunal, if I mention the word rightly. But the most important part that or before that, there's also something that he mentions about trade unions, and he clearly states that that has to do with employees coming together, forming the trade unions, and to advance employees' interests where necessary. And he also made mention of very important things that I wasn't aware before, that is the existence and activeness of also some certain trade unions. But where we stopped in the last session was that some misconceptions that people have about the Department of Labor. When he started discussing was somebody saying in the social media that they have submitted some claim for inspection in certain corporation or business, and it was not done. And we will let him continue from that to clear this and other misconceptions that people have the Labor Department. I, for one, also have heard that the Labor Department is not active, that when you contact them, they don't respond, all sort of things. And today we have the opportunity, Mr. Barrow, so that you help us clear these misconceptions that people have about the Labor Department.
Yeah, thank you very much. As I already told you about some of this information that go around the social media, that is one recent. Of course, we are not receiving such information. Somebody who said he has submitted a letter to the Department of Labor to inspect certain workplaces, and then he said he has given me the letter. That's what I was saying. Letters don't go to the Commissioner of Labor. Letters go to the records. And the records will put it in the mail folder and submit it to the commissioner. Commissioner will minute it to the action officers to do the actions needed for that particular thing. Yeah, but it was saying this, which I cannot even remember such things at the moment. And going to this TikTok saying such things, it doesn't tell. Well, what you should do is to come to the department and make your findings. The one you gave the letter to, come to the department and find out from the inspectors whether such thing happened, or even to come to me directly. When it comes to me, and I will let the inspectors find out whether such things are here. Yeah, but saying something that is not true about the department, it doesn't tell well. I know that is it. But sometimes you have to see such things when you are doing something like dealing with people. You are dealing with parties like the employers and the workers. Of course, you want to see certain things. Whoever is not satisfied with what you do, they will say a different thing. Like sometimes you can handle a dispute, maybe the employer is not satisfied, and or sometimes you do it, then the employee is not satisfied. So the thing is, since the venue is available for you to go to that place, that is industrial tribunal, then you can always do that. Don't come to labor and say, because especially if the findings or the mediation is not in your favor, you always want to say, they have not treated the case, or they have not done anything about it. That is not the issue. That's why you have these industrial tribunals. The law is very clear. If the case could not be settled within a specified period, in fact, within 1 month, the worker or the employer or the union representing the worker or any other party can take the matter to the industrial tribunal. This is what the law provides. So if you choose not to go to the tribunal and you said there's nothing happened to my case, this is where the problem comes. The tribunals are established purposely for this, labor courts. And having all these things across the country is all about the cases to go to the tribunal when they could not be settled through mediation. You know, the mediator, of course, not all of them will be satisfied with what you do. If it is in favor of me, I will say good. If it is not, I say no. I'm not satisfied with this.
Yeah,
yes,
I think that is very clear. I think what what I believe or what I think is going to be the major reason for that misunderstanding is people will actually misinterpret mediation and judicial powers for enforcement, because you are mediating, you are trying to reconcile sort of, so you don't have the ability to say you must this by force, you must do this by force, you know, or you don't have the authority to say you have to do this. So you are trying to hear both parties and try to bring them into terms so that they can cordially exist at the environment. So
in fact, some people thought the department is for only workers, and but it's for both workers and employers. That's why you have the trade unions. Those pursue the interests of the workers only. And you have the employers organization. Those are also for the employers. So, but labor is neutral. We are a referee between the two parties. You can always see, even at our homes, when you mediate something, somebody may not be satisfied, and they will start saying all sort of things. Yeah, but for those who are sending information to our office, send it properly, especially if it's a letter. Come with your way book. Deliver the letter. If they receive the letter, they will sign. That will be an evidence that you have submitted something to my department. Rather than to do it today like that, and at the end of the day, you started complaining. I submitted this in there, and nothing has happened to it, and you've given us names that nobody understands. So that is the situation. I think everybody try to walk along this line. We always need information. Any information that we have, we make sure we act on that. It's not that whatever you tell us what is right. Sometimes you go and inspect on an information, and they come to find out that what is told you is different. It's what you found at the workplace. So, but there are certain information that they are very vital. Then when we go and find out, we find the truth. We find that what they have said is what happened in there. So we start to work on that. So it happened like that.
I agree with you to some extent, but I also want to be a little bit of neutral here. I think some of it is because of the frustrations that people or citizens have when they want to launch a complaint or want to inquire information from public offices. Now, this may not be related to labor, but sometimes you want something in a public office or a ministry. They will tell you go to place X, place Y, place Z. But you go to place X will tell you is place Y. You go to office Y will tell you is office X. You go to office X will tell you go to office Y. And then at some point, you don't even know where to go because they are not giving you, they keep the information as if it is supposed to be something that no one should know about. That's one, when you are inquiring information. Sometimes when you are even delivering, let's say, a letter, and you mention that it's a letter of complaint or a letter of claim of something, the people in the offices would not guide you through. They frustrate you. This is, I'm not saying what the person said is right, but I believe this is a general frustration that citizens sometimes go through in public offices. You go to seek for information, it feels like you have to bring the skies down to get it when it's a public information. You go to put up a claim, and the persons that are supposed to listen to you, nobody wants to listen as soon as they know the objective. Sometimes it's a letter, they don't even put it in the process where it's supposed to be. They just trash it. They put it in a dustbin. I have experience when I was, and I think when I finished high school, so I submitted my documents, and then when I just left, exit, I pulled back the door, but it was not 100% closed. So it's like I just turned, and then coincidentally, I saw the lady tearing my papers.
What?
Yeah, she tore them and then she put them in the trash. I did not go back to have any conversation. I just left. So maybe this could be an instance the person just carried frustration from other departments or other experiences. It could be the reason why people are easily, driven into this way of thinking. I don't know what you think about that.
Yeah, but now in government institutions, there is a record office everywhere, every ministry, every department. What you need to do, submit your letter to the records, and especially if you have a Weibo. I know not everybody will carry away, especially individuals. Yeah, but as an organization, especially this particular one, you can come with a Weibo. Then they receive the letter, they will sign. That signature will show that the letter has been delivered to that place. Yeah, but if you cannot show any evidence of that, and telling people, yeah, I've submitted this, that's where the problem.
So in the case of an individual, what would you advise? In the case of an individual submitting a letter, so you don't have a wake book, how do you deal with
you
that?
have to take it to the records. Yeah, because like it's happening to you, you can even have your own somewhere to sign, like somebody to sign that he has received this letter from you.
Okay.
Do that since it's happening to you, and you cannot have evidences. So that will be your evidence. So tomorrow, if somebody said, or the department said, I have not received this thing, then the thing will be settled at that department level, because at least you have delivered it.
Okay.
Yeah, maybe he has not read the commissioner, or he has not read the permanent secretary, but at least there is an evidence that it's delivered to the department or to the ministry.
Okay.
That will definitely help.
I think that's a good advice.
Yeah.
Just one question to the regarding the inspection before we move to the next part of the discussion. Do you have authority to enforce recommendations when you go for inspection? Let's say, for instance, somebody send a claim to you that the work environment is X, Y, and Z, and then you get there to inspect, and you find out the claims were right. Do you have authority to enforce recommendations of changes in the environment?
Yeah, that's what I told you last time. When you go for inspections, they make recommendations.
Okay.
The two parties will sign. The employer will sign, and the department will also sign at the spots, and they share the documents. Then they will tell you, they will come back and make sure these things are taken care of. So they will go back again, and maybe they'll find out you do some and you have not done still some. The industrial relations, social dialogue is very important there. So we still give you a chance to settle out. But if you come to a situation where you fail completely, that time the matter should go to the court.
Okay.
Yes.
Okay. So labor will put the matter to court.
Yes. Yes.
Okay. Okay, that's good.
Yeah.
So let's move on to the employment itself. Contracts, types of contracts, and rights of employers, rights of employees, disciplinary action, and all those sort of things. Can you guide us through what is available?
Yeah, thank you very much. We have what is very important in employment relations, that is contract of employment. Some people just call it employment letter or appointment letter.
Or sometimes offer letters.
Yeah, offer letter, whatever you call it. But the Act call it as contract of employment. And you have three types of contract of employment. One is a specified contract. The other one is unspecified contract. And the third one is specific task. This bind the two parties, the employer and the employer. These are the agreements. And the Act said this agreement has to be in writing. You can hear some of the complaints. People say, this place, they have not given a contract of employment, or they said they are not given a letter of appointment, and this is. And it's important that everybody know, for this 2023 Act, is compulsory. It has to be a written contract of employment.
Oh, so that's compulsory.
It has to be in writing.
Okay.
In 2007 Act, of course, there are loopholes where you can have contract verbal. But in 2023, all contract has to be in writing. And the one thing the employees who normally complains about it, they have an advantage even where there is no written contract.
Okay.
The employer supposed to do that. They're supposed to do the contract and said with the employee to sign, and it become binding on them. And one thing, they have to make sure that it's in line with the Act. any contract that contradicts the act is null and void.
And void.
Yes, so that cannot be enforceable. So that's why we offer this service to the public, to the employers, to attest their contract. Bring it to the Department of Labor, we look at it and make sure it's in line with the act.
Do they do it?
Yes, some are doing it.
Some?
Yeah, because sometimes what happens when they have a case, it comes to the department and we look at the contract, we know there's an issue with the contract. So from that, they will go and do it properly, yeah, and we do. But some will just send it, because they know about it. They know about it.
But if I don't understand law a lot that much, but if the employer comes to the labor department to put up a claim, and then you realize that the employment letter or the contract that the employer offered to the employee is in accordance to the act, null and void.
It's not in accordance.
Yes, that means there are some things that it did not meet
with the requirement
of the act.
Yeah.
So in that case, can you act on that claim or whatsoever?
No, you cannot act on something that contradicts the act. We will ask you to put your house in order.
Okay.
Yes, and a contract that's supposed to be in writing and is not put in writing, that contract is enforceable by an employee.
Oh, come again.
And a contract,
yes,
that's supposed to be in writing,
yes,
but it's not put in writing,
yes,
that contract is enforceable by an employee.
The
contract is there. Okay. Even though it's not writing, the moment you have employment relations, there's a contract.
Okay.
You are working for somebody, is paying you a salary. You're going to work every day, doing your work. It's a contract. It's just verbal. But the law says it has to be in writing.
Okay.
If you fail to do it, and that employee is the one who can enforce that contract. That's why I'm saying it's enforceable by the employee. That means any doubt, the benefits of the doubt will go to the employee. Because when you bring a case, the first thing we look at is the contract of employment. If there's such no contract of employment, then there could be doubts.
That is the employer falling short of that.
Okay. There could be some issues that will not be clear to us.
Okay. So
yes.
You mentioned three types. You said specified, unspecified, and specific task.
Yes.
What are the distinctions among them? Those three.
The specified contract is what we call the fixed term contract.
Okay.
Some people call it a fixed term. The contract specifies the date of the contract and also specify the day the contract will end. Yeah, you work for a project that is for 1 year. They give you a contract for that period of 1 year. That is fixed term contract. That's what we call the specified contract. Then you have another contract called unspecified contract. That is we call the permanent contract. You know the date of the appointment, but the date of the ending of the contract is not specified. So that means we call it a permanent contract. That contract can only be ended when there is termination of contract. Then there is a termination of contract due to some reasons. But this termination, maybe we'll come to that. I don't know whether the time will allow us. Hopefully. This termination of contract will also, you cannot just terminate the contract like that, because some people have the feeling that, okay, I am the employer, I have the right to employ, but I have the right also to terminate. But the law said you have to justify your terminations. That's what they ask for, justification of termination.
So I'll put a point there. I will come for that on justification of termination.
Yes.
When do you terminate a contract of an employee? But specific task.
Yeah, the specific task that like you assign me to do a work for you, maybe to clear a field or to do something that is specific, and we agree that when I finish this work, you pay me so much. When the work is finished, the contract is ended. That is specific task. So these are the three. So you either be employed on one of them, either be specific task or unspecified contract, that is the permanent contract, or specified contract, that is fixed term contract. These are the three types of contract.
Elaborate for us the rights of the employer.
Yes.
And the rights of the employee.
Exactly. Employers and the employers both have rights as specified by the act, the new act. They are numerous. Yeah. So that's why some of them like the employer has rights, like the employee has the right to receive written contract of employment. That is right. Now that becomes a right. And also to work under satisfactory conditions. That is his right or her right. And also to receive equal pay for equal work done. If you
Does that include extra work hours?
No, I mean
equal pay for equal work done.
If I am,
let's say the work, I'm trying to jump in a little bit because time, unfortunately, like you were afraid of, we have been informed about time. But let's say your employment letters, employment letter says from 8 to 5, okay?
Yeah.
But you start work and there's an incomplete task. So beyond 5, can the employee claim extra work hours?
Overtime?
Yes, overtime.
Yes, if it's assigned.
If it is signed.
If it's assigned to do the overtime.
Okay, if they are assigned.
Yes.
That, what do you mean if they are assigned?
Like your time of closing is 4 o'clock.
Yes.
So your supervisor or employer told you to work extra hours.
Yes.
Yes.
So
those extra hours you work should be paid as overtime.
So you can claim.
You can claim, yeah.
But what
if
it is not written in the letter of contract, contract of employment?
Okay, maybe not everything is in the contract, but the Act has covered some of
the Act has covered that.
The Act, or what we call the Joint Industrial Council agreements.
Okay.
They cover some of those, and they are all binding.
So people can actually claim that.
Yeah.
Because, you know, I'm asking this because I know there are a lot of people out there who are working extremely overtime and they think they cannot put up a claim. They are not aware.
They can claim for it.
They can claim for it.
If you are assigned to do it, then you have to do it.
Okay. So
I don't want you created it for yourself and the employer do not ask you to do anything like that.
Okay. As long as it's the employer that tells you to stay and work, then you should be able, you are entitled to claim for that.
And the payments are different. Even if that is time and a half.
Thank you.
Yes.
Thank you so much. So I'm trying to push you a little bit to contract because of the timing.
Yeah.
So give us a little bit of rights of employers too.
Yeah.
Then you can sum up with the termination aspect, justifying termination.
Yeah. I've not exhausted that one of the employer.
I know.
But still time is not.
Yes,
there.
time
Anybody
is not outside.
Go to the Act.
Okay.
You will see. I advise everybody to get this copy of the Act, the new Act of 2023.
So where can we find
it? You can get it from printing.
Printing.
Yeah, GCci.
You pay for it?
I think it's about $500.
500.
Yeah, anybody can get it from there.
Okay.
Yeah, employers also have rights like to employ, to discipline, to transfer. All those are the rights that they can do, though they have to do it in accordance with the law that provides, and that make programs for the company, the policies and the programs for the company. Those are some of the things they have the rights to do. Yeah, and also modify, extend, and cease operations if they want. Yeah, sometimes the employer cannot just say no. You cannot close. You cannot cease operation. Those are the rights of the employer. What the employer need to do is to pay you your benefits when you want to cease operations, and also to determine the type of product, whatever they want to do, the type of product they want to produce or they want to work on is their right. You cannot determine. You can advise them, but you cannot determine that for them.
Okay, I have one point. We have 2 minutes, but I have one point I want to quickly raise.
Yeah.
Let's say I'm working for you, for 5 years, 6 years. Is it the rights of the responsibility of the employer to upgrade, to train the employees to improve their skill set in the same work to increase productivity? And also, if the employers are not doing that, does the employee have a claim on that, that they need to be trained? And also, just wrap up, if they are doing this by themselves, let's say the employer is not training me, but I decided to take up some courses to improve my my skill set. What does the Act say about that?
In fact, that is specified. If we have time, I will have highlight all those things. Those are duties of the employer. In fact, it said here training. Training of an employee is your duty. To be productive, to be efficient, it's your duty to do that. Training is, in fact, I think that's an advantage to the employer, to train your staff so that they will be able to deliver as expected. So training is vital, it's very important, and that the law provided it, that employers, is part of the employer's duty to train his employees. Yeah.
All right. Yes. So one last thing that you can tell our audience that we have not discussed, and we close the show.
Thank you very much. We have not come to the end of some of the things that we want to say. One thing I want to emphasize is this. is the licenses of the what do you call them? Licenses of the employment
agency.
Yes.
Yeah, I know we don't have time for that.
Yeah.
So we will find a way to bring you back on that subject. But just one word to tell our audience about the act, what they can do.
Thank you very much. What I want to tell you, the act is of 2023 is out now. It's been gazetted, and it will be very important for each an employer, even the employees, can get a copy of this thing. At least acquaint yourself with the act. We will do our sensitization, but you know we cannot reach everybody. Even you come to QTV every day, I cannot reach everybody.
Right.
So, but you have it, you can read it. Where you have a problem with this, get to us, and then we explain to you. We are not legal people, but we can also get advice from our legal people, from the Ministry of Justice.
Thank you. Unfortunately, even though we had 2 sessions, time wasn't on our side to complete what we wanted to discuss. Until we come your way next week, this was GCCI Business Matters. I am Malik M. Jallo, and please don't forget to pass by Tijania Fashion for all your, best suits and casual wear. Until I come your way next week, this was GCCI Business Matters. Malik M. Jallo. Thank you.
This program was funded by the European Union.